Good morning. Thank you for joining us for day 2 of the Energy Law Lecture Series. Our first presenter of the day is Mr. Neal Pierce, an attorney at Steptoe and Johnson who works in both Ohio and Texas.
My discussion today, presentation today, I titled for purposes of the law review, The Quick and the Dead. Those of you who are biblical scholars will recognize the reference and be able to sort through the meaning. But in a large sense, when we're talking about production-related savings events or saving clauses, we are essentially talking about the basic principle of either being quick or being dead. Let me start by just saying a word about the article itself, because my presentation is going to be just sort of a short version of it to focus on a few points. One of the things that Steptoe and Johnson as a firm has been focused on in the last 3 or 4 years as the shale play has developed in the eastern states where we primarily operate, is the fact that many of the jurisdictions that we operate in, while they've had oil and gas production for many years, they have fairly incomplete legal precedent in many areas. And so one of the things that we've tried to do essentially as part of our broader perspective on what it means to be a lawyer, what it means to be a professional, is to undertake, to find opportunities to draft scholarly articles that look at the broad view of oil and gas issues, that is, surveying specific issues to see what virtually all the jurisdictions in the U.S. are doing with regard to particular topics. The idea being that that sort of research and writing gives lawyers on both sides of an issue and judges law clerks, who most often write the opinions, a place to start with their analysis of any particular issue, and that there are some positive insights to be gained by understanding the similarities and differences between the approach that any particular jurisdiction takes to an issue dealing with either land rights or leasing or the interpretation of the operative provisions of a lease. And so in essence, the article, if you take the opportunity to get the volume that's being produced by the North Dakota Law Review, will have an extensive survey of about 30 jurisdictions. What I'm going to try and talk about today is, with regard to the issue of temporary cessation and shut-in clauses, is the two jurisdictions which sort of frame the debate, the schools of thought on these two issues, and then a few selected states to give you a flavor of where those states may be in relation to the cessation, temporary cessation, and shut-ins. And while this presentation is primarily not about North Dakota law, it probably is instructive, because certainly North Dakota has case law from its first round of oil and gas development, which indicates that they've looked at the issue of temporary cessation. And the fact that there's now a new round of development on top of old leases suggests that these issues will, in some circumstances, come to the fore. Although one of the things that we discovered as we were putting the paper together is that the older your oil and gas production history, the more likely, for instance, that the temporary cessation doctrine is going to have ongoing significance in your state. And I noted as I was preparing specifically for this presentation that, for instance, while exploratory activity looking in North Dakota started in the 40s, the first successful well was drilled in 1951, whereas in Pennsylvania, the first successful well was drilled in 1857. In Ohio, 1860. In West Virginia, 1859. And we've had some interesting presentations. One of the things we're going to talk about is the nature of an oil and gas lease and what sort of a property right it is. And the issue's not as clear as you might think. In 1893, for instance, the Ohio legislature passed a bill requiring that oil and gas leases and contracts be filed in the record room. Now, the question is, why would the legislature pass a bill that requires that leases be filed in the record room? Every idiot knows that leases need to be filed in the record room. In 1893, at least in Ohio, it wasn't clear that an arrangement to extract oil and gas from someone's farm was in fact a lease. Many of them were termed as licenses. Many of them were termed as contracts. And to the extent they weren't considered interest in real property, and in Ohio in 1893, they were considered something else, a form of personalty. The statutes didn't require that they be recorded. Hence, a specific provision in the Ohio Revised Code in 1893 that requires that oil and gas leases and contracts be filed. That statute is still on the books in a somewhat variant form, but other than the folks in this room and maybe 6 other people in the world, nobody knows why that statute was introduced. But it's because of this sort of fundamental difference in the view of what an oil and gas lease is and does. So, enough introduction. The nature of the interest created by an oil and gas lease. There are sort of 2 schools of thought, one of which is represented by Texas. And in Texas, fairly early on, looking at this issue, the Texas courts determined that the nature of an oil and gas lease, with a primary term and a habendum clause, was to create a qualified or determinable fee estate, fee simple determinable. The interesting thing is, if you talk with a Texas lawyer, they assume that because the law is like that in Texas, that it's like that everywhere in the world. One of the things that flows from it being a fee simple determinable estate is that once you get into the secondary term of the lease, the issue then becomes when does the lease terminate in the secondary term? And because of the nature of the interest in Texas being fee simple determinable, the answer is the lease automatically terminates at the point in time that production ceases after the primary term. No requirement of notice, no determination of a default, no essential right to cure the default. The lease terminates as of that point. On the other hand, Oklahoma, looking at this issue, comes to a different view, which is to say that an oil and gas lease doesn't convey an interest in the real estate, but rather it transfers a right to explore and mine the leased premises. It's in the nature of a license, or some states refer to it as a profit, others as a incorporeal hereditament. I mean, think about saying that day after day. Let's call it a profit. And what that essentially means is that the nature of the interest is the right to go onto the premises and to extract, in this case, oil and gas, but not a right of ownership of any sort in the asset in the ground. Oklahoma then sort of takes the secondary view that once oil and gas is actually produced, the nature of the interest changes. However, many of the states who view an oil and gas lease as a profit rather than as a fee simple determinable estate don't take that second step. It's merely a right to enter into the premises and extract. But one of the interesting things about it is that because Oklahoma takes the view that it's not a fee simple determinable estate, they also take the view that a lease will not automatically terminate upon the cessation of production in the primary term. What that means in a sense is that for an oil and gas lessee, his claim to continuing ability to be on the premises, to have the rights that are associated with his lease continue, notwithstanding the fact that there's been a cessation of production. Now, as we move through this, I'm going to suggest that the differences between those two views are fairly subtle. But to the extent that any particular jurisdiction leans one way or the other in terms of how they view the nature of an oil and gas lease, whether they view it as a real property interest or whether they view it as a form of intangible personal property, has some impact on the way the courts think about the issue of temporary cessation versus a non-temporary cessation, and what the implications of that are in terms of the ultimate issue, which is the lease continuing to be valid or has the lease terminated? The early Texas cases on cessation of production in the primary term were fairly strict and followed their view of property law, which is it's a fee simple determinable estate. Once you get into the secondary term, if the triggering event occurs, the lease is over. Needless to say, in certain circumstances, there was a certain amount of screaming and agonizing, particularly by the producer community. And fairly early on, the courts in Texas recognized that their view of the oil and gas lease as a fee simple determinable estate and the logical conclusion that followed from that oftentimes generated harsh results. And so Texas, as a matter of the application of equitable principles, developed an equitable remedy which which we call the temporary cessation doctrine. And I say that Texas developed it, but in fact, Texas was not the first state to recognize a temporary cessation doctrine, but they recognized it as purely a matter of equitable remedy to ameliorate the effect of the legal principle that they'd adopted with regard to the nature of the oil and gas lease as a matter of contract and real property. So, the question, does a temporary cessation of production from the premises result in the termination of an oil and gas lease? Solution, temporary cessation of production should not result in a forfeiture or termination of the lease if the cessation of production is unforeseen and unavoidable, and if the lessee is in good faith using reasonable diligence to resume production within a reasonable time. Now, how many of you can identify the undefined terms in that concept? We have temporary cessation. We have unforeseen and unavoidable. Good faith, reasonable diligence, and a reasonable time. Interestingly, Texas generally takes the view in terms of weighing the equities that the primary focus is not about how long the temporary cessation is, but what's the nature of the temporary cessation. And so in the Texas cases, you see an emphasis on mechanical problems with the wells. Something happened to the pump jack, something happened to the pipeline, something happened to the equipment that forced the wells on the lease to be shut down for a period of time. Generally in Texas, in the absence of some physical reason for shutting the well in, they seldom apply the temporary cessation doctrine. And so before you even get to the question of how long is temporary, in Texas, you need to have a sort of, I don't want to call it a force majeure event, but you have to have an issue with the production of the well itself to get you over the threshold into the question of then, one, what's a reasonable period of time, and two, what constitutes reasonable conduct to get the wells back online. The Oklahoma approach is a little different, and again, it's a subtle difference, but I think you can appreciate it. In Oklahoma, the leading cases indicate that a lease continues in force during a period of cessation of production, unless the period of cessation is unreasonable. So, I mean, you can see, you can sort of see the policy indicator. In Texas, you start with the idea that once the flow of production stops, the lease is terminated, unless you can make an equitable case that there was a good reason that production ceased and that you did what you could. In Oklahoma, the cessation in and of itself doesn't forfeit or terminate the lease. Rather, the lease continues during the period of non-production until it reaches a period which would be considered unreasonable. That doctrine was cited by the Oklahoma courts in the mid-1950s. But, as you see, in 1958, in a separate Oklahoma case, a court trying to explain the Oklahoma principle indicated that the lease terminates by its own provisions when oil and gas are no longer produced, except where there are equitable considerations. So at the end of the day, both the courts in Texas and Oklahoma view the question of temporary cessation ultimately as one that requires a court to consider the equities of individual cases. That in turn suggests things about the way courts go about this, and also about the way we as practitioners try and understand the rule. Because it's all driven by equity, every case is fact specific. Because it's driven by equity, every case depends on the consideration of a number of factors. Because it's driven by equity, at the end of the day, it's what the trial judge thinks is fair and what the appeals courts think is not irrational. So that the trial judge says, I looked at everything, I'm saying the lease is still good, up to the Court of Appeals, okay, maybe we don't agree with it, but we've got rules about when we can overturn your findings, so it's okay, or we looked at it and that's nuts. Lease is terminated. That can be difficult when you're trying to advise clients with regard to their leases as to whether they're valid or not. And so what's the solution? In the mid-continent, in Texas, in Oklahoma, once these cases started to come out, it became in the interest of both lessors and lessees not to rely on the equitable principles of the court. And so most leases, starting in the 1950s to 1960s, started putting in cessation of production clauses, and you all have seen the typical clauses, and they sometimes they try and define operations, but generally speaking, the periods of time in a cessation of production clause are relatively short. Both states take the view that where there's an express lease term dealing with temporary cessation, it eliminates the application of any common law rule. The good news is that cessation of production clauses add a degree of certainty. That is, to the extent that the parties have talked about it in the lease and they have come to an agreement on what temporary cessation means, they now have an understandable provision that will tell them whether the lease has been terminated or not. The bad news, in a sense, is that cessation of production clauses often, by express terms, set up shorter periods of time before the lease is forfeited than would be applicable if you applied the equitable principles. Although, as I'll try and discuss, how long is too long is a really broad question and varies a lot from jurisdiction to jurisdiction. So, a reasonable trade-off, defined shorter period of time for temporary cessation versus an end to uncertainty, probably in most cases, but there certainly are cases where express terms of leases have forfeited or terminated leases that might have survived a legal analysis in the states where those leases were operational. I want to talk about a handful of states and their approach to temporary cessation. But I just want to reemphasize the point that I've made earlier. If the news in real estate is location, 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 the news with regard to temporary cessation is equity, equity, equity. And as a result, regardless of whether your jurisdiction tends to fall in the Texas camp or the Oklahoma camp, if you are dealing with leases that don't have an express temporary cessation clause, it's important to remember that there are a set of rules for issues that are considered by a court sitting in equity. And we sometimes, as practitioners under the federal rules, tend to forget that. In the course of the research, one of the interesting cases that we came across was an Indiana case called Barrett v. Dorr. And Barrett v. Dorr was the case which Ohio used as its primary precedent in its leading temporary cessation case. When you read Barrett v. Dorr, which is a pre-federal rules of civil procedure case, clearly by looking at it, what you see is a very well-reasoned decision by the Indiana court, who understood the principles of equity and who wrote an opinion walking through step by step their analysis of the application of equity principles in Indiana. And so reading that case is very instructive in a sense in understanding the nature of the analysis if you're in litigation over what constitutes temporary cessation. The states I want to talk about: Colorado, Kansas, Ohio, West Virginia, North Dakota. Colorado and Kansas, I think, generally aren't sort of the lead states with regard to important oil and gas doctrines, but clearly they're influential states. And interestingly enough, in recent years, a number of the courts in the East have looked both to Colorado and Kansas for precedence on issues of first impression dealing with other provisions of the lease. That suggests to me that those courts, all of the things being equal, are likely to look at what Kansas and Colorado are doing on these principles as they are to look at Texas and Oklahoma. Colorado has not explicitly adopted a cessation of production doctrine, but they do, in those circumstances where there has been temporary cessation, look at relevant lease provisions, the circumstances, and considerations of equity. The interesting thing is that in Colorado, much like Oklahoma, discovery of a well in commercial, a discovery of a well that's capable of producing in commercial quantities satisfies the habendum clause going into the secondary term, and so in some sense, Colorado, although they haven't spoken to all of this, they tend to follow the Oklahoma view of what will allow you to move into the secondary clause of the lease. One of the collateral issues in looking at temporary cessation cases is cases where the question of temporary cessation doesn't involve wells that are not producing at all. It involves wells that are producing something, but there's an issue of whether they're producing and paying quantities. And so oftentimes there are spillover issues in terms of balancing the equities. And one of the ways that the courts will balance the equities is they'll look at the situation and they'll say, well, okay, we think that you've made the case that you did enough with regard to this well, and so we'll let you hold acreage associated with that well. But otherwise, this lease is terminated. Now, what that sounds like is an application of one of the implied covenants, but the courts often aren't clear. And Colorado in particular, in terms of their approach to equity, is fond of issuing orders in cases after they've looked it over, saying we're going to terminate this lease conditionally. That is, with regard to the acreage held by this well or by these wells, you have 60 days to submit a plan to get these wells back into production. As to the other acreage on the lease, the well is forfeited, or the lease is forfeited if you don't come up with a plan for development over the course of 6 months. And I'm certainly not suggesting that they're the only state that does that, but in terms of temporary cessation, they were one of the few states where we saw an equity approach that said, well, we'll split the baby by saying the lease ain't over yet, but if you don't get something done here right shortly, then the lease is going to be over. The Kansas courts, interestingly enough, have looked at the question of temporary cessation fairly extensively. There are a number of cases. Wagner versus Sunray is one of the lead cases, but I list 3 cases there. Tate versus Stanlin, Brack versus McDowell, Wagner versus Sunray. When you read those 3 cases together, you see sort of some fundamental jurisprudence in Kansas. 3 factors that are relevant to whether a cessation of production is temporary or permanent: the period of time of the cessation, the intent of the operator, and the cause of the cessation. In general, no one of these elements can be isolated and held to be decisive. This analysis in Kansas is interesting, and particularly interesting to you all, because the lead case in North Dakota with regard to temporary cessation cites these Kansas cases and cites this 3-prong analysis for determining temporary cessation. That in and of itself is suggestive that the Kansas approach to temporary cessation is influential. But as you read these cases, I mean, it's certainly a well-reasoned approach, an approach that makes sense for a court in looking at a set of facts and trying to determine whether a lease is over or not. Kansas, like Texas and Oklahoma, recognizes that if there's a contractual provision, it's going to supersede any applicable common law doctrines. And Kansas also has some case law that talks about, in the context of temporary cessation, whether a lease which is non-producing, which is partially in a unit and partially out of a unit, if the court determines that the cessation is temporary and that the lease is still valid, whether that lease remains valid with regard to the non-unitized or non-pooled acreage. West Virginia, one of the very early states to look at this sort of issue, and held that a lapse in production and the duration of the lapse is relevant but not determinate. Again, a state that tends to fall into the Oklahoma school view that the cessation event itself doesn't terminate the lease unless there are other factors to be involved. The most explicit case in West Virginia, Bryan versus Big 2 Mile, makes that fairly clear. I want to talk about Ohio for just a moment. Although I'm licensed in both Ohio and West Virginia and spent a fair amount of my career practicing in West Virginia, I am a Buckeye at heart, and at least insofar as Steptoe and Johnson is concerned, I'm an Ohio lawyer. Nobody really remembers that I still have a West Virginia license. The Ohio courts have adopted a temporary cessation view. As I said, they cite Barrett v. Dorr. Their view of it is that it's an application of equitable principles, but they come from the Texas view of what happens in the secondary term if there's a cessation, which is the lease terminates unless principles of equity apply. Interestingly, Ohio comes to that view having never definitively said that a lease is a fee simple determinable estate. In fact, the early cases in Ohio indicate that Ohio's view of an oil and gas lease is that it's a profit or a hereditament. But the more recent cases, the more contemporary courts look to Texas law fairly extensively in their analysis, and there are a number of intermediate Court of Appeals decisions that lean in their decisions on the view that a lease is a fee simple determinable estate. My view, in a sense, is that they've come to that conclusion because the easiest thing for their law clerks to do when they're writing opinions is to find Kramer's treatise. And Kramer's treatise certainly treats Texas as if it's the leading state. Ohio, interestingly enough, is one of the few states where you can sort of come up with a rule of thumb from the cases about what's temporary cessation. And in the Wagner case, they cite Barrett v. Dorr favorably. In Barrett v. Dorr, it was a period of cessation of 1 year. In the Wagner case, it was a period of cessation of 2 years running into 3 years, in which they terminated the lease. Do I have the Mack case up? There it is. In Ohio, 1981 Intermediate Court of Appeals decision indicates that a 3-year period with no production was fatal to the lease, even though the lessee resumed operations after that time, which means even though the lessor was receiving a royalty check, 3 years of non-production followed by a royalty check didn't constitute an estoppel. I think Ohio is one of the few states that's probably gone there. Nevertheless, you can say in Ohio, when you're advising clients and you're looking at acquiring held by production leases, and you want to know, should I defect this lease or not? And I've got this gap in the production. What do you think? And the answer is, gee, if it's 2 years or less, yeah, maybe it's okay. If it's more than that, and you're offering $3,000 an acre, maybe you ought to put it on the defect list. Or maybe you ought to say, I'll give you $500 an acre for this one because I think it's got some issues. North Dakota, where a lease has been extended by its primary term by production, temporary cessation of production will not automatically terminate an oil and gas lease. The Phelan versus Placid Oil decision, 1969, the court's very clear about where they are on their equitable analysis. And unlike Texas, which is focused on what caused the event, or like Kansas, which is focused on how long an event, the North Dakota courts take that analysis to heart, but I think the Phelan case suggests that they also took the Kansas view that no issue is determinative to heart. They talk specifically about not the inequities to the lessor, but interestingly, they're one of the few courts that talk about the potential inequity of the temporary cessation rule to the lessee. And what's the nature of that inequity? The nature of the inequity is that oil and gas development involves large investments of money at high risk, and therefore, as a matter of policy in applying these equitable principles, there is something to be said on the lessee's side of the equation when you're trying to balance the equities about investing large amounts of money. Interestingly, there's an Illinois case that talks about this in the context of development in Illinois, which is like Ohio, lots of small producing oil wells, stripper wells. And they talk about it in terms of, geez, these are small wells, they're marginal producers, these guys are mom and pop operations, they're trying to make a living, maybe we can cut them a break. The other end of that equation is what we're looking at right now. We're drilling huge wells which require huge investments to acquire leases, huge investments to build pads, huge investments to get to the site, huge investments to get the well drilled, huge investment to complete the wells, and in a court of equity, all of that investment and all of that risk ought to mean something in terms of these questions of how long is too long with regard to temporary cessation. All right, enough on that. We're burning up the time. Is there anybody here from the law review? Here's the deal. Originally, they said that I was supposed to talk for an hour and a half. I said, nobody wants to hear this for an hour and a half. Let's just do an hour. So do I have an hour, or do I need to go a little longer? I have an hour. All right. We're moving through this then. Let's talk about the nature of shut-in payments. The Texas view. Shut-in royalties are periodic payments for the privilege of deferring exploration and production after the primary term. Oklahoma. Shut-in royalty clause allows the continuance of the lease without actual production and marketing of the shut-in production by the substitution of stipulated payments for the royalties. So, shut-in payments are in the nature of a substitute payment of royalty, and therefore, where you have a shut-in clause, it's designed to substitute for royalty and keep the lease valid where production would be required to keep the lease in force. What that means in a sense is, in virtually all jurisdictions, you got to have a well that's capable of producing and paying quantities in order to trigger your shut-in clause. The shut-in clause is not a substitute payment to allow you to continue the lease past the primary term because you can't get anything out of the ground. The other interesting thing is that shut-in clauses, and maybe this is overstating the obvious, but shut-in clauses are really a provision that deal primarily with gas wells rather than oil wells, because the issue is, once you drill a well that's capable of producing, what do you do with the product? Well, with gas, with natural gas, it's got to go into a line. And sometimes when you're drilling in areas where there's not infrastructure, you've got to wait. Hence the shut-in clause. Oil, on the other hand, can be pumped to the surface at any time, as we've discovered over the course of history. Dig a pit, put the oil in the pit, bring the wagon and the horses up there and haul it out, bring a truck up. A lot of oil is moved by pipeline, and so you potentially have the same issues, but temporary cessation is more of an oil well issue, and shut-in clauses are more of a gas well issue. Interestingly, in Oklahoma, because of their view that a lease doesn't automatically terminate for almost any reason, non-payment of a shut-in royalty after the end of the primary term doesn't automatically terminate a lease. Whereas in Texas, you need to be pretty careful if you've got a well drilled that's not producing as you come to the end of the primary term and into the secondary term. Before you get to the last date of your primary term in Texas, you better have made your shut-in payment. And one of the things that our survey paper sort of focuses on is whether any particular state falls into the Texas view or the Oklahoma view of when the shut-in payments are due as you come to the end of the primary term. Interestingly enough, in a number of the states like Oklahoma, where they would say as long as you have a well that's capable of producing and paying quantities that carries you into the secondary term without actual production, they also hold that if you have a shut-in clause in your lease, it applies both in the primary term and the secondary term. So if you didn't have a shut-in clause, your lease would remain valid because you had a well capable of producing and paying quantities. If you put a shut-in clause into your lease, then you better be prepared to live up to the express terms of your lease. Kansas is one of those states that takes the view that you only have to have a well capable of producing and paying quantities as you go from the primary term to the secondary term, but they also indicate that if you've got a shut-in clause, the express terms of the shut-in clause will apply. Again, Colorado tends to follow the Oklahoma view, but they've expressly said that where the parties choose to insert a shut-in royalty clause as an additional special limitation, it requires the shut-in royalty payment at any point the gas isn't marketed. In the states that Steptoe primarily practices in, 160 years after the first oil and gas wells are drilled, West Virginia still has no cases on shut-in royalties per se. There is one interesting case where a lease was non-productive for 8 years and it changed hands a couple of times, and therefore the lessor sought to have the lease terminated for non-production. The lessee responded by sending a shut-in royalty check on a lease that had no shut-in royalty provision. The West Virginia Supreme Court prudently determined that they couldn't imply a shut-in clause where none existed in the lease. And finally, Ohio. Again, 150 years after the first well in Ohio, very little to say about the application of shut-in royalty clauses, but there is one case. Moore versus Adams, which stands for a very important principle, which is if you have a shut-in clause in the lease, it's probably not in your interest to wait for 5 years until your landowner complains before you get your checkbook out and write the check. Tardy payment of a shut-in royalty provision will not meet the obligations under the lease and will likely cause the termination of your lease. So, I call it stare decisis because whether your jurisdiction sort of follows the Texas rule or the Oklahoma rule, at the end of the day, you're wrestling with equitable principles which are going to be determined on the facts of the case. As a litigator, that may serve you well. As an advisor to clients, having to tell them that in every case, you got to consider, here's the factors that you consider, here are the things that you should be aware of, here are the risks that you're taking, blah, 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 don't have an answer for you. That's what they're hearing, and what they want to know is it 1 year, is it 2 years, or is it 3 years? What should I do? And the answer oftentimes is what they don't want to hear, which is, geez, it's been a long time, maybe this lease isn't any good, maybe you're taking a lot of risk. Go back and ask your CEO what his risk profile is, because as a lawyer, I can't tell you that. I appreciate the opportunity to come and talk with you. I hope that you'll take the opportunity to get the issue of the North Dakota Law Review that has all the presentations. I can tell you that having looked at 30 states on these two topics, the article is long. I quit counting the footnotes after 700. You don't have to read all of them, but I think we pretty thoroughly covered the case law to the extent that you're interested. Thank you.